Welcome to today's program titled ERISA Litigation Updates, What 2024 Told Us to Expect in 2025, Looking Back and Looking Ahead. At this time, all participants are in a listen-only mode. For those of you who are logged in to the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to this form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I'd like to turn it over to our first speaker for today's program, Ian Morrison. Ian, please go ahead.
Thank you, Kate, and good afternoon, everyone. It's a pleasure to be here with you all and talk about some exciting and challenging developments in the world of ERISA litigation from last year and in this year so far, even though it's barely even a month into 2025. There's been a lot to cover, and we will try and do our best to do that. I'm delighted to be joined here today in the offices of Seyfarth Shaw in Chicago by my partners and friends, Sam Schwartz-Fenwick, Tom Horan, and Ada Dolph, who are here to share their wisdom and experiences on a wide range of ERISA topics. So I'm going to just briefly cover the agenda on the next slide, kind of give you a very high-level view of what we're going to talk about today. I will kick us off by talking about what's been going on with ERISA arbitration. Tom will then talk about ERISA fee litigation, and then I think Sam will talk about some developments in the medical space in the fee litigation arena as well. And then I'll talk briefly about the recent ESG decision, and then Sam and Ada will talk about what's going on at the Supreme Court and some shifts in pleading standards. So hopefully you'll leave the program fully informed on what's going on and equipped for the new year. So with that, I'll kick us off on the next slide with a brief discussion of what's happening in the world of ERISA arbitration. If we can go to the next slide, where I think we've landed after this issue has been litigated extensively in the lower courts is that all of the courts agree you can arbitrate ERISA claims. There's no barrier to putting in your plan arbitration language. The fight is about whether you can also effectively couple that with a class action waiver that has teeth. And the challenge in the ERISA space has been that ERISA statute specifically provides that participants and beneficiaries can sue to get relief that goes to the plan as a whole. And in an effort to bar that, many arbitration provisions have stated that any relief either sought in a class action or sought on behalf of anyone other than the actual named plaintiff in the case is precluded by the arbitration provision. That's been challenged in a number of courts, and to date, the vast majority of the appellate courts that have looked at this issue have declined to force arbitration where the plaintiff has objected to individual arbitration of claims that seek remedies for the plan as a whole. The courts have relied largely on what's referred to as a judge-made doctrine called the effective vindication doctrine, which essentially says it's okay to force people to arbitration, and that Federal Arbitration Act makes arbitration agreements enforceable in court, but you can't take away people's right to effectively vindicate statutory rights they may have. And where that's come into play in the ERISA space is that if you're trying to take away participants' rights to seek certain forms of plan-wide relief, then that may implicate the effective vindication doctrine. And on the next slide, we've listed out some of the recent decisions that have ruled, applying the effective vindication doctrine, that arbitration could not be compelled in these situations, and you'll see they span several circuits. The principal argument that's been raised by the defendants in these cases, which to date has not gotten traction at the lower courts, is that, well, the Supreme Court has referred to the notion of the effective vindication doctrine, it's never actually applied it, and therefore we should not assume that it is actually something that exists in the face of the clear language of the FAA and the Supreme Court's very strong pro-arbitration decisions applying the FAA. But that argument, as I noted, has not gotten a lot of traction to date in the Court of Appeals. And the Supreme Court has, as recently as late 24, declined to take up appeals from these decisions, finding that there is no arbitration. So, so far, the Supreme Court has not been interested in the issue. That's not to say it will never get there, but to date, I think the lay of the land is being shaped by the appellate court rulings. On the next slide, we just wanted to flag a related topic we've talked about in prior panels, which is the notion of putting a venue provision into your plan and requiring participants or beneficiaries who sue under the plan to bring claims in a particular forum. That was something that has been adopted by many plan sponsors as a way to manage where their cases are litigated. But as the tendencies of the circuits has shifted over time, it becomes a little harder to know where you're best off in terms of specifying a venue. One particular risk is that in the Second Circuit, in particular, there are some cases, and this is actually on the next slide, I apologize, I've skipped ahead one. Cases dealing, Kate, if we could go to the next slide and I'll come back to this one. Cases dealing with jury trials under ERISA. Most of the courts have said you don't get a jury trial in ERISA cases. However, in the Second Circuit, there have been a line of cases, I would submit, relying on a faulty reading of the Supreme Court decisions that have allowed jury trials in some ERISA cases, and there have actually been a few. So you would want to be careful if you're going to put in your plan a forum selection clause, providing that you're going to have to litigate in a particular forum, make sure that you're not forcing yourself into a jury trial. And we'll talk later on about the American Airlines decision from Texas, which is another object lesson, and be careful where you choose to litigate your cases, because you may be stuck with judges who have very strong opinions about some of the practices you're engaged in. And if we can go back to the prior slide, on I think a related point, even if you have arbitration provisions in your plan, given the recent Supreme Court ruling in Badgerow, likely if you were to win an arbitration, you're going to have to go to state court to enforce that. And I think there would be good arguments that you're then stuck in the forum that you selected in the plan for enforcing, plan-related provisions. And so again, you may be stuck dealing with, in that case, in state court, enforcing arbitration, but also, with a particular forum choice. And the same would be true if you try to seek review of an adverse arbitration decision. We've often cautioned that the remedies for a losing party in arbitration are very limited. And that's also affected by the circuit law or the state law that may apply to those arbitration decisions. So some things to consider as you ponder whether to put arbitration in your plan if you don't have it, or whether to enforce it if you do. And with that, let me hand it off to Tom, and we'll skip forward a couple slides, and Tom will talk about some of the fee litigation developments.
Thanks, Ian. Okay, we can go one more. So if we think about kind of where we are in fee litigation at this point, it's hard to kind of talk about it without talking about where we were from a comparative standpoint. So if we go back, this time last year, right, coming out of 2023, we saw filings in the ERISA class action space decline in 2023. Settlement activity was up, and we were kind of at a sleepy posture with respect to ERISA fee litigation going into 2023, with the expectation that the combined effect of declining filings and increasing settlements would be more capacity in the plaintiff's bar, and at some point filings would return with a vengeance. And we did see that trend play out. It took a few months longer than I think we expected at this time last year, but come mid-year 2024, we saw a significant spike in filings, and there were about 50% more cases filed in the second half of the year than in the first half of the year, which I think is a trend that we've seen continue into this year. It seems like every day there's news of a new filing or more than one new filing. Some of those we've seen have, and we'll talk about in the coming slides, involved new legal theories or evolutions on legal theories that we have seen in recent years, and some of that has driven the new filing activity. The other thing that we have started to see play out in increasing numbers is a trend towards suing smaller plans. Some of that might just be a reflection of the reality that a lot of the large plans have been sued at this point. But we saw suits filed in 2024 against plans that had less than $250 million in plan assets, and really an effort to settle or to pursue claims against those smaller plans. Similar to 2023, though, we also saw an increase year over year in the number of settlements of ERISA cases. At the same time, we saw a decrease in the average settlement size, and a notable number of cases settling for numbers at or under $2 million of settlement value, which really seems to reflect that there is a willingness, at least among certain firms within the plaintiff's bar and defendants faced with these cases, to look at these really as a cost of defense situation and to settle for lower numbers than we've been used to seeing in years past, even before the outset of significant discovery. So with that kind of background on where we are, I think we can move to the next slide and talk about, more specifically, some of the legal theories we're seeing. Forfeiture cases certainly weren't new in 2024. We saw these start to pop up in earnest in late 2023. But at this point, I think we've got enough data to say the trend's not going away at this point, right? We're up over 30 class actions that have been filed related to the use of forfeitures, and sort of table set there, right? When we're talking about forfeitures, we're typically talking about the money that's been left behind in the plan when an employee or participant leaves the company before all of the money in their account has vested. So you're usually talking about employer matching contributions or other employer initiated contributions to the plan that vest according to some schedule, and an employee leaves before those are fully vested. Money's in the plan, and the question arises as to what to do with it. Under applicable IRS guidance, and this feeds into some of the arguments that we'll talk about in the cases, that money can be used to offset future employer contributions to the plan and to fund matching contributions to the remaining participants, so long as the plan document allows for it. So what we've historically seen is that plan documents would be drafted with something akin to a co-equal list of ways that the forfeitures could be used, that included examples of things like to offset employer contributions, or to pay administrative expenses, or to cover other costs that the plan and its sponsor faced in the operation of the plan. In these lawsuits, what's been challenged is the suggestion that if you're not using the forfeitures in a way that directly benefits participants, and at least as the cases argue, to reduce the costs that participants face, for example, you're exercising your discretion under the plan document in a way that benefits the company over the participants and violates various provisions of both ERISA's fiduciary duties and some prohibited transaction claims. One of the things that these cases really signal is the willingness of the plaintiff's bar and the plaintiffs in these cases to challenge things that have long been accepted as common practice in the industry and try and find a hook for the new avenue to kind of spur litigation. I think the other reality here is that a lot of the underlying allegations in these cases are really challenging set law decisions, right, around what's permissible and how these things are going to be used. within the plan, and we've seen that play out in some of the initial motion to dismiss arguments and the decisions that have come out in some of the ways that we've seen companies try and deal with it. So if we go to the next slide, while a lot of these cases remain at very early stages and motions to dismiss have not been decided in many of them, we have sort of started to get a sense of the trends and the most likely arguments from both sides. From the plaintiff's side, there's really an effort, I think, to oversimplify what's going on here, to leave the court with the impression that this is a simple cut and dry issue and that something nefarious is going on. Right? They're really trying to boil the claim down to an allegation that the fiduciaries in the plan are choosing to use plan assets, the forfeited funds, in a way that benefits the company over the participants. The claims typically include violations of ERISA's anti-inurement rule, saying that the plan assets can't inure to the benefit of the plan sponsor. Allegations around the duty of prudence, but really more the duty of loyalty, saying that they're prioritizing the company over the participants, and then the prohibited transaction claims. The defendant's arguments certainly are nuanced in the various cases, and in some cases can tie more specifically to the language in the individual plans. But there are also kind of overarching trends that we've seen. One is that this is plainly allowable under the current regulatory environment. And if you're going to allow claims that categorically say you can't use, or there are reasons why under the prohibited transaction rules or otherwise you can't use forfeitures to offset employer contributions, then you're undoing what the guidance says. There are arguments that really the claims are not attacking fiduciary conduct, they're attacking settlor decision making over either how the forfeited assets can be used, how benefits under the plan are going to be funded. And in some of the more recent cases, the argument has even advanced to the point that the benefits any participant is owed under the plan are obviously a product of what the plan terms say. And if you're going to institute a requirement that forfeited assets be used first to offset participant fees, you're essentially requiring the plans to confer a benefit on the participants that the plan document doesn't, by imposing a requirement that the forfeited funds be used in certain ways first. As to the prohibited transaction claims in particular, there are arguments that really the use of forfeitures only involves redirection of assets that are already within the plan, and so there is no true transaction as the rules would look to, and so you can't find a prohibited transaction claim there. And we've seen those be successful in a couple of cases, which we'll talk about on the next slide. So to this point, we've seen 7 decisions on motions to dismiss in the forfeiture cases. 2 of them have denied the motions and 5 have granted the motions. It's important to note that on the situations where the motion to dismiss was denied, it doesn't mean that the plaintiffs are ultimately going to prevail. It just means that the courts in those cases, based on the allegations, found the claims asserted to be plausible. In the instances where we've seen courts deny the motions, the focus has really been on the plan language and the idea that the plan document gives the fiduciary discretion over how the forfeitures are going to be used. And the exercise of that discretion then under ERISA is bound by ERISA's fiduciary duties. And it's at least plausible in those courts' eyes that the fiduciary should prioritize uses of the forfeitures that benefit participants and not the company. And the same reasoning ultimately carried through to the question of whether the use of forfeitures to offset employer contributions really did confer a benefit on the plan sponsor, or if it was ultimately just a question of allocation within the plan. And the court said, certainly you have arguments there, and we'll see what evidence plays out, but at least at the pleading stage, that's plausible. On the flip side, in the larger number of cases where the motions to dismiss have been granted, really what the courts have, with the notable exception of one case that turned heavily on plan language, what the courts have focused on is really the breadth and the impact that the plaintiff's theory would have here, and the almost categorical rule that these claims so far have suggested that would require the use of forfeitures on the front end to offset participant paid expenses before they could really be considered for anything else. The courts have in these motions to dismiss have been inclined to say basically that goes too far. That can't be squared with the regulations. That can't be squared with the guidance that's out there in the way that this has been interpreted and applied for years now. And so while, in most cases, I think in all cases, the motions were dismissed without prejudice to repleading some narrowed version of it, what the courts have held is that what's been pled at this point is too broad. In the one case that I mentioned turned significantly on plan language, what was significant to the court there was that the plan at issue actually sort of built in a priority and a hierarchy of how the forfeited assets should be used, and really took the discretion away from the fiduciary and said the forfeiture should first be used to offset any contributions and kind of proceed on a schedule there to the extent there's anything left over. It's too early to say for sure, but there is certainly support building for the idea that reviewing plan language and making sure that fiduciary practices and the administrative practices as to forfeitures is aligned with what's allowed in the document, and whether it's worth revisiting the idea at least suggested by that one case and some other commentary that removing discretion as to the use of forfeitures might prove to be a valuable defense in these cases. With that, I'll turn it over to Ada to talk about another one of the new trends that we're seeing in ERISA class action litigation.
Thanks, Tom. So speaking of new theories of fiduciary liability, so Tom's given us sort of the scorecard on the forfeiture cases. If you can go to the next slide, please. I would say one of the most recent theories that we've seen appear is pension risk transfer cases. You'll often see them referred to as PRT cases because they are becoming prolific at this point. So we're in the double-digit number of lawsuits that are filed. These started coming in 2024. And essentially, and kind of going off of what Tom was saying, they're challenging acts that have sort of traditionally been viewed as settler functions that are, at the desire of the employer in terms of what to do in terms of handling the pension risk and liabilities. So this is a big business that happens. There's about $45 billion per year transferred out of plans into annuities. And the issue here is challenging a particular annuity provider by the name of Athene. This is, again, we've seen these trends in ERISA class action where there's sort of a deep dive on a new type of theory. There's going to be some waiting and seeing to see what the courts do. Are they going to get past motions to dismiss or not? We're in the very early stages in all of these cases. The common denominator is that each of them involves State Street as an independent fiduciary that was involved in selecting Athene as the annuity provider. And then all except one very recent one involved the selection of Athene. So we just had a case filed last week against Verizon that again had State Street as independent fiduciary, but had Prudential as the selected annuity provider. So essentially what's happening in these cases is that the plaintiffs are arguing and acknowledging that there are regulations that allow for this lift out of risk to an annuity, but they argue that the process that was implemented to select the provider did not comply with DOL guidance. And they focus on what they allege to be the additional amount of risk that is the harm, they allege, to participants for selecting an annuity provider that has a private equity control and other types of investments that are somewhat different than traditional ones. So the guidance they're talking about is the Department of Labor Bulletin 95-1 that the Department of Labor reviewed this year. The report came in, it was late by the Department of Labor, and they'd been requested by Congress to take a look at this guidance. And essentially the DOL reported that it's functioning fine and they had no specific changes to recommend. The guidance itself does use the term safest available annuity provider, but it also has all kinds of factors that are part of that consideration. And as you can surmise, plaintiffs may have a different idea of what constitutes the safest available annuity provider from a plan fiduciary looking at the specifics of their own plan. So initially, these cases have been focused on sort of lift outs from plans of certain benefit groups. We're seeing it now start to challenge even plan termination situations. I'd say the major issue that we expect and that we're seeing play out in the motions to dismiss, every defendant in these cases is moving to dismiss, is around the grounds of standing, which we've seen come up many times in front of the current Supreme Court and is definitely a focus of attention for them, as well as in prior cases where there was a challenge to the investments by an employer to pay pension benefits going forward. So here, the standing issue is that these participants all have received 100% of their benefits. There is no indication of any kind that Athene or the other annuity providers will not be adhering to the contract. And yet they're arguing that the selection of a different annuity provider increased their risk, essentially. Seyfarth has appeared as amicus in many of these cases. And what we've been focusing on is, again, this concept that the settler decision to transfer risk out of the plan is something that is expressly permitted by the regulations, expressly permitted to the extent an employer doesn't have to maintain one of these plans. Obviously, they can't cut back benefits, but there's no obligation there to maintain them in some certain form. And so plaintiffs are arguing that the coming out of an ERISA plan by itself, that the lack of PBGC backing for plans that fail, and some other consequences of PRTs are causing them this harm. And when we've been talking about and looking at this, in fact, each of those are consequences of any pension risk transfer. So where is the harm here? So that is going to be the main focus of these motions to dismiss, is whether the plaintiffs in these cases have standing or have suffered some injury that could be remedied in the litigation. So I imagine we'll have a scorecard for you in a few months on how these cases are shaking out. I'll turn over to Sam.
Fantastic. Kate, if you could go to the next slide. So another area where we've seen the plaintiffs bar try to develop a new theory is by trying to use the theories of 401k fee class actions and bring them into the welfare space. So one of the first and boldest efforts to do this was recently in Johnson & Johnson. So about a year ago, this class action was filed, and the theory put forward by the plaintiff was that prescription drug charges under the plan were too high because they were charged at rates significantly above what was available at, just market rates per the allegations. And also that things like employee compensation were being held down due to the amount of money being spent on the contract with the pharmacy benefit manager, the PBM. So it was pretty much suggesting that because of the plan's contract with its service provider here, the pharmacy benefit manager, they weren't alleging that participants weren't getting what they were required to receive under the plan, but rather that due to fiduciary breaches, the inflated costs that the plan was bearing impacted both what participants were having to pay for drug rates and also what they were, their co-pays, and allegedly because such a big percentage of J&J's corporate spend that, was set aside for employees was going towards paying these drug costs. There was less money available for compensation. So that was their theory. Last Friday, we can go to the next slide. I'm happy to report there was oh, let's go to one more slide. Sorry about that. Last Friday, there was some really fantastic news in that the District of New Jersey, rejected these theories. The court issued a motion to dismiss without prejudice, so plaintiffs do have time to amend, but it could be challenging unless they really reformulate their theory. So the issue of wage suppression or having to pay higher copays, the court said that this is a speculative injury, and thus it's not enough to show standing. And so we're back to the standing issues that Ada and Tom were both addressing, or that Ada was really focused on in the PRT claims, and it's really the first hurdle plaintiffs have to overcome. So the court was saying, you need to show some type of causal link between, their contract with the PBMs and this parade of horribles you're alleging. You can't just say CA, CB, we have standing. You need to show this nexus. So the court gave them an opportunity to replete that. The court did say that as to the allegation that their folks in the plan were paying above market rates, the court said that is enough to state an injury, but that here the named plaintiff couldn't state an injury. And that's because she hit her deductible every year. So even if she were to win, she wouldn't be getting any money back due to these allegedly inflated prices. So it wouldn't be a benefit to her. That seems like an issue that plaintiffs could more readily find a named plaintiff who could meet the standing requirement. But even if they did, given the court's focus on the deductible, it's hard. It certainly would skew significantly downward the ultimate recovery of any class member, and thus might make this type of claim less desirable for plaintiffs. Now, before we all do, a victory dance and say, these claims are going south, it's important to remember that the first fee claims, when they went to motion practice, many of them were struck out in motions to dismiss. Plaintiffs learned. They figured out nuances and way to state viable claims. And now, 19 years later, they, remain the most commonly filed class actions in ERISA litigation. So I would say that from our perspective, we're not really surprised that the J&J case was largely dismissed. There was a penalty claim that was allowed to move forward due to ignoring a document request pre-litigation, but that the substance of the claims were dismissed. But we think given really the anger towards health plan, how health insurance exists in our country right now, there's going to be a lot of smart and energized people on the other side trying to figure out ways around these theories. And I wanted to just say Lewandowski is consistent with a recent decision out of the Third Circuit. Kate, if you can go to the next slide, and that is in Knutson versus MetLife. Again, it was a suit against PBM or regarding an employer's relationship with the PBM. Here, the plan didn't require the rebates received by the employer from drug manufacturers under its PBM contract. It didn't require it to be used to reduce participant expenses. So the employer was actually using this to help mediate its costs under the health plan. As most of the folks on this call know, employers contributions to health plans typically dwarf what employee contributions are. I think in J&J, almost 90% of the costs borne or, attributable to the health plan were paid by J&J, not its employees. And certainly, and so the court found that since the plan didn't require these rebates to go to drug manufacturers or to go to participants to reduce their expenses, there was nothing imprudent about, or they said, there was no injury to plaintiffs. The court didn't really reach the merits, but I think that's something that really colored the court's view, was just that on its face, this didn't really seem that problematic to the court. So I think that, the broader picture definitely plays in here. But this is similar to the holdings in the forfeiture cases of, are you acting in a way consistent or inconsistent with the plan? Now, again, the court said that it might find standing if plaintiffs could restate a theory in which they linked the amounts they had to pay under the plan, either through premiums or copays or whatnot, on their failure to receive these PBM related rebates. I think that's a hard road for them to hoe, and the court seems skeptical of the overall theory of the case. But we're in a watchful waiting standpoint here as we really wait for the second generation of these cases to be filed. And with that, I'm going to turn it back over to Tom.
Great. Okay, we go to the next slide. This one doesn't fit quite neatly in the category of sort of trends we're seeing or new theories we're seeing, but it does tie into something Sam mentioned happened in the Lewandowski case, on something that we haven't addressed in some of our recent webinars, and in light of some recent decisions, wanted to take a few minutes to talk about, and that's ERISA 104b4 document requests and related penalty claims. So as Sam said, one of the things that survived the motion to dismiss in Lewandowski was the plaintiff's request for documents to the plan administrator that was ignored until after the litigation was filed. As a reminder, ERISA 104b4 requires that within 30 days of a written request from a participant, the plan administrator provide copies to the participant of certain categories of documents specified in the statute, including the SPD, the annual report, a terminal report, a collective bargaining agreement, if it's applicable, the trust agreement. And then it's got sort of these categories in 6 and 7 that are where we see most of the litigation. A contract or any instruments under which the plan is established or operated. So there were 3 cases in 2024 that we wanted to highlight, in addition to last week's Lewandowski decision. The first was in January out of the Northern District of California. This was all of these cases involved denied claims for welfare benefits and participants who were bringing suit challenging those decisions. But in addition to their benefit claims, had penalty claims saying either that the plan administrators had fully failed to respond to their document requests or had refused to give them certain documents that the participants believed were required, largely under that category 6 or 7 contract or other instruments. So in the Northern District of California case, the court declined to award penalties where the plan administrator had refused to provide its administrative services agreement with its TPA. The court there looked to the language in the statute and said, really what 104b4 is talking about is the documents that tell a participant, how do you become covered in the plan and what benefits are you owed? And what it doesn't cover, and what the court there found the ASA went to, was basically how does this plan operate on a day-to-day basis, and what are the kind of under the hood operational things. And so under that reasoning, the court said you don't get penalties for not getting the ASA. The court in that case did award some limited penalties. While the statute and regulations authorize penalties of up to $110 a day, the court noted that it has discretion to lower the penalty. And in that case, there was sort of a unique set of facts. The original document request came in sort of in the heart of the pandemic, when nobody was reliably in the office, nobody saw the mail. It seemed to be undisputed that this request just got missed. And so the court said under that explanation, there was no reason to award the maximum penalty, and it awarded only $15 a day as opposed to 110. I think that sort of argument probably carries a lot less weight now than it would have 4 years ago, because people should be more adjusted to that reality and should have practices in place. But it's an important reminder that if you're going to include an address in the SPD and other places where people can direct these document requests, to ensure that you have appropriate practices in place to make sure that somebody's going to get that request and respond to it. The other two cases stand out, one from the District of Montana and one from the 10th Circuit, because the penalties were significant. In one case, they were $100 a day, and in another, they were the full $110 a day authorized. And both really talked about the administrative services agreement and the question of was it required either as a contract or an other instrument. And in those cases, the courts looked at things like the ASA was really the document that governed where benefit claims had to be directed and identified the parties that were going to be making benefit decisions under these welfare plans. And I think in the District of Montana case in particular, the court rejected, and I'm going to quote here, the notion that the employer's reading of the statute is not requiring the ASA ultimately was not a defense to knock down the payment amount. The court said there that it didn't matter that the refusal to provide the ASA was based on a good faith misreading of the law rather than a bad faith intention to deprive access to information. The statute clearly requires it, and it was appropriate to award maximum penalties in the court's view. It's possible that and one of the things we've discussed is that the need to provide the ASA or sort of documents beyond the core set of plan documents that you think of as sort of immediately responsive to a 104B4 request might be more acute in the welfare space, where there are often a lot more documents that factor into decisions and eligibility and who's acting in a particular space. But we thought these cases, coupled with the Lewandowski decision, serve as kind of a reminder of the importance of scrutinizing the document requests you get and making sure that you're taking them seriously and responding to them in a timely and appropriate manner. And consulting counsel is necessary. So with that, I'll turn it all the way back over to Ian to bring us into our next topic.
And I just want to interject with just one sort of practical practice pointer around trying to navigate these different jurisdictions' view of whether the ASA is one of the operative documents that needs to be provided. There's a difference between refusing to provide a document and declining to provide a document, meaning I think a good way to make sure that door stays open and you understand if you have a situation where the plaintiff is asserting that the ASA impacts their benefit is to provide the core documents and to make sure you leave that door open in your responding letter. Something like, we believe we've provided the applicable documents. Please contact us if you believe there are other documents that you require, something like that. I mean, all of these small little good faith attempts to comply and to provide the information that the participant is looking for do play a role here in these penalty cases where the judges have really wide discretion, as you're seeing.
Thanks, Ada. And next up, we're talking about the recent American Airlines decision out of Texas. But before getting to that, obviously wanted to say that we are all thinking about and our thoughts are with the families of those who were affected in the tragedy last night in Washington, D.C., both the military side and the civilian side in that incident, and everyone who is responding to that disaster. We know these are difficult times for those affected. So if we go to the next slide, the case was decided early in January, and this was sort of one of, I think, two so far that have been filed. One was filed against a public pension plan. This is the first private sector pension-related case that's been filed challenging what are referred to by the plaintiffs in the court as ESG investment practices. The suit focused on the use of so-called ESG principles in proxy voting by BlackRock, which managed the plan's passive index portfolios. And the plaintiffs essentially contended that even those are passive index portfolios, which, as I'm sure everyone on the call knows, are built to match the weighting of an index, that nonetheless, this proxy voting behavior turned them into covert ESG funds, to which the plaintiff objected. So the plaintiff sued for breach of fiduciary duty of prudence and loyalty. The court denied summary judgment, denied the motion to dismiss, certified class, and took the case to trial. Where we stand now is the court has issued a decision or findings of fact and conclusions of law, finding no breach of the duty of prudence, and then surprisingly a breach of the duty of loyalty, despite the fact that the court said that the practices at issue were prudent. There's been no ruling on remedies. The parties are submitting briefs on remedies in mid-February, so we'll see what shakes out there. We can go to the next slide. The court's findings of fact and make the point, which is noted a few times on the slides. These are the court's findings. You can certainly read the opinion and you'll get a deeper flavor for how the court viewed this case. And I think these findings are all fairly heavily colored by the court's perception of what I think it would say were the evils of ESG. But what the court essentially said was plan delegated proxy voting to investment managers, BlackRock and others. In BlackRock's case, BlackRock's requirement was to follow its own proxy voting policy. That policy did focus on voting proxies to be consistent with the interests of the economic interests of the assets under management. Over time, some so-called ESG considerations were added into those. The court criticizes the defense and BlackRock for what the court says is essentially sort of wrapping these policies and attitudes in language having to do with economics, and goes so far as to say, you can't change the fact that you're making climate change related proxy votes with economic labeling when, according to the court, and this is a quote, using such labels as a clever pretext, particularly when dealing with an unproven and nebulous issue like climate change. I think that gives you a flavor of where the court is coming from. The investment management agreement and the IPS required BlackRock to report on proxy voting and certify its compliance with its own policy. I expect that's a fairly common set of terms. According to the court, the plan advisors, the investment advisor, and the internal staff who were responsible for investment management didn't get certification from BlackRock, didn't talk about proxy voting, didn't discuss the issue at all until a lawsuit was filed. And then the court cites what it calls, some extensive internal correspondence, which seems to be a handful of emails that sort of suggests that American, as a plan sponsor and a corporation, was in sync with BlackRock on ESG values and ideas. So on the next slide, what did that lead to in terms of findings? Well, the good news, if there's good news in this decision, is the court found for the defense on prudence, saying essentially prudence is process, prudence is determined by industry standards. What they did here was completely in line with industry standards. The plaintiffs produced no evidence to the contrary, and that's enough to win them the prudence claim. But then the court goes on to say, and spends a couple of pages sort of denouncing the entire investment management industry and retirement plan industry, calling it incestuous and saying it's essentially impossible for somebody to challenge these practices as a matter of prudence because everybody's doing it, and because everybody's doing it is therefore prudent. The court clearly was unhappy with what it saw or reported seeing in this space. So then I think looking for a way to find some liability, the court moves on the next slide to loyalty, and essentially says that the employer here failed to keep its corporate interests and its focus in ESG separate from the focus on the best interests of the plan, and allowed this sort of cross-pollination of influence and interest. The court also focused fairly heavily on the fact that BlackRock, unsurprisingly to anybody who knows anything about investments, was a very large holder of American Airlines stock. American Airlines is a large cap domestic stock. It is on big indexes that BlackRock manages index funds to track, and so does State Street and Vanguard and many, many other providers. And as a result of simply that passive activity, these investment firms own large amounts of pretty much everybody's stock. Yet the court seemed to pull that out and say, well, that means that the company is conflicted in sort of allowing BlackRock to do what it does. Court also cited some evidence that BlackRock held, I think, about $400 million in corporate debt of the plan sponsor, and pointed to that as well to suggest that there's a kind of a nefarious set of relationships here. And then found some emails that were presented at trial that suggested that the investment management personnel at American were aware of the significant relationship, as the court called it, between BlackRock and the airline, and that somehow suggested they were choosing to turn a blind eye to ESG proxy voting. And the court strung all of that together to say there's a breach of duty of loyalty. They didn't focus enough on the pure economic interests of the plan, without really getting to what I view as one of the key questions, which is how was any of this activity at odds with the economic interests of the plan participants? I think you would hear from the investment managers that they are pushing companies on practices that may in the long term or short term, depending on what's going on in political environment or the market or the planetary environment, have an effect on the value of the stock, and it's appropriate to do that as an investment manager. But that was lost, I think, on the court. So on the next slide, obviously this is simply an initial phase decision. We're going to get a ruling on liability or damages rather. It's unclear whether there is any damage model that's viable here. I'm skeptical, but the court, having found liability, is at least going to award attorney's fees, I would expect. The decision is clearly driven by this judge's particular views. This judge has a long track record of taking some fairly strident and extreme views on issues, and was probably sort of chosen by the plaintiffs who filed in this particular forum in order to have a good chance of getting a judge they liked. The decision also, as I noted, sort of improperly conflates the realities of the investment market with nefarious behavior, and I think other judges would not view it that way. It's also terribly unclear what the court thinks is ESG. The court goes through an exercise of trying to say this is and this isn't ESG investing, but I think the label will probably persist despite any attempt to kind of actually categorize it and explain what it is. The one takeaway, if you're looking for something from a fiduciary perspective, is process is important. Obviously, that won the prudence claim, and I think one of the hooks that the court latched onto to find against the defense for liability was the failure to follow through on getting certifications from the investment managers about proxy voting. So if you're looking for a sort of takeaway from this that you can act on, I would say it's that. Just double down on making sure you're doing all of the things you're supposed to be doing. But more to come, and we'll have to see if as in the other areas, there are a lot of copycat suits. But with that, I will hand it back off, I think, to Ada next, I think, on the pleading standards.
Thanks, Ian. And actually, Tom, I think you were going to cover this section, but happy to proceed. Okay, so we've talked about the pleading standards for fee claims, and we just want to make a note on this because essentially we don't expect ERISA fee class actions to slow down anytime soon. And we had, at least from a defense perspective, high hopes that the Supreme Court decision in Hughes versus Northwest University would give us some very specific pleading guidelines for courts to use to decipher whether a claim was plausible or not. We're seeing lots of comparisons in the fee class actions to fees that are disclosed in Form 5500s, and comparing massive plans to smaller plans, and then arguing that there is a showing that the record keeper is being paid far too much in, for example, the smaller plans. And there are lots of quantities of scale and lots of reasons why fees are not discernible from a Form 5500. You can make an estimate, but is this the kind of thing that should allow a complaint to go forward? So Hughes, as we've talked about before, was not particularly enlightening. And Kate, if you can go to the next slide, please. So we are seeing a little bit more of comparison of what I would say are apples to apples versus apples to oranges. Like I was talking about, two vastly different plans, two vastly different record keeping arrangements, those kinds of things. Next slide, please, Kate. But it's still hit or miss, certainly. So some of these inconsistent results obviously are going to continue to drive ERISA class action filings in different jurisdictions across the country. Some of the areas they differ in is, as we were just talking about, the standards for showing that the fees are unreasonably high. Standing remains, again, it should be a focus for every court, given the Supreme Court's heavy emphasis on that piece as well. That we're also seeing some somewhat inconsistent rulings. And then, as was mentioned earlier, around jury trials, certain jurisdictions are ruling differently. So it's sort of getting harder to figure out which jurisdiction might be the most favorable from a plan sponsor, plan administrator perspective. Next slide, please. And I'll just touch on this. Sam talked earlier about how there are some issues with pleading standing in these health plan fee litigations. The more difficult that is, and the more the courts are rejecting those, obviously that will make that a difficult challenge for those cases going forward. But until that's decided, we expect that litigation to continue, just as we do with the forfeiture and the pension risk transfer cases. Next slide, please. And one more. Okay, so looking ahead to what we expect from the Supreme Court in 2025, there was an oral argument held on January 22nd in front of the Supreme Court that was very interesting. And I know most people's eyes gloss over when they hear the term prohibited transactions, and they're trying to understand how this could impact these cases or the prevalence of these cases going forward. Essentially, what it comes down to is there is a provision in ERISA that excludes certain transactions from being called prohibited. And the plaintiffs are arguing that what Congress intended is that every transaction between the plan and a party in interest, which is a very broad definition of basically anyone that has had any relationship with the plan, the plaintiffs are saying that that by itself can be pled and brought forward to pursue litigation, and then that the exceptions that are shown in a different section of ERISA must be shown by the defendant. So in the example of fees, that the fees must be shown to be reasonable and necessary. Or if you're on the plaintiff side, that they were unnecessary and unreasonable. So there's been two decisions that came out different ways. The Ninth Circuit in the Bugielski versus AT&T case came out the opposite of this one, and the Ninth Circuit essentially said the starting point is every transaction is a prohibited one, and then it's on the defendant to come back and prove that there's an exemption, or what it refers to as an affirmative defense applies. The Second Circuit in this Cornell case came out exactly the opposite. However, it remains to be seen how it's going to impact, I think, the pleading piece. Next slide, please. So what was interesting about the oral argument is that the judges were kind of all over the place. There was really no consistent question from any of the justices. You could kind of understand what options they were exploring. We had, for example, Clarence Thomas say, well, if the transaction that is being alleged is a standard transaction and you can't show that the fees were unreasonable or unnecessary, then there should be no standing. But the plaintiff's response to that is that the transaction starts off as prohibited. There's your harm. That's all you need to proceed as a participant. And in response to that, the Cornell University was saying, well, why would Congress allow you to plead a claim that has no standing? So there's some different commentary back and forth on all these different provisions. So it will be very unclear to see how this shakes out. I want to hand it over to Sam so we can get in the last case.
Okay, and I know we're at time. I'll try to go fast, but for folks who have to run, I just did want to tell you the CLE code. It is S as in Sam, S as in Schwartz Fenwick, 3030. So the last case we want to briefly touch on is Scrimetti, which is dealing with the constitutionality under the 14th Amendment of the gender affirming care bans for minors that we've seen pass throughout the United States. Now, it's important to note that these bans do not prohibit, in most cases, ERISA plans continuing to provide these, to cover these types of services. What they do is make it much harder for participants to obtain these coverages. So a lot of plans have put in place travel benefits and things like that to allow individuals to obtain coverage of these benefits. But given the executive order this week, whether that is a viable long-term solution is in doubt. But the issue here is really whether under the 14th Amendment, these laws constitute sex discrimination, because they're not banning they're not banning these procedures in all cases. They're only banning them when the reason sought for taking these medicines or having a specific surgery is due to gender affirming care. So if you're taking puberty blockers because you have early onset puberty, that's not excluded by this law, by these laws. The other argument is that these laws, they're targeting a vulnerable community, and thus a higher level of scrutiny is required. It's uncertain how the Supreme Court is going to rule here. Gorsuch and Barrett are going to be the deciding votes one way or the other. It's possible that you could have a decision with a lot of different where the majority opinion is actually, it has to be read by splicing together a whole host of concurrences. And I say that because Justice Barrett's concerns seemed not as much focused on the discrimination argument under the 14th Amendment, but instead on the notion of parental rights and whether this was a inappropriate insertion of the government into parental rights. So stay tuned. I think it's likely that the Trump administration may seek to have oral argument reopened in this case in light of its recent executive orders and just the real shift in policy. But even a victory in this case for the transgender youths who filed the lawsuit might be short-lived if the terms of the executive order from a few days ago are carried out, because that would prohibit doctors, many types of insurers who receive federal funds, and healthcare entities from providing these types of coverage, and potentially extend criminal penalties to parents who allow their kids to undergo it. So I think this is in many ways the first round of Supreme Court cases on this topic. So I want to thank you all for attending today. We really appreciate it. And please feel free to reach out to any of the four of us with any of your ERISA questions.